Hello, everybody. Just going to give it a couple minutes to let people come in, and then we'll get started. Hello, everybody. Going to give it a couple minutes.
Hace tuco, maje.
Vuela.
Dale, pedite recto. A la derecha, ¿viste? A la derecha.
Dale.
Espérate, para, pero no todo. Frená. Atrás. Frená. El otro. El chiquitito. Recha, el chiquitito. Espérate.
Well, that didn't end well.
Quédate.
All right, today I want to start off with the findings with that UPS plane where the engine came off, and apparently there's something seriously wrong with these Boeings, and this guy is pretty good when it comes to explaining what's going on and what's happened, and anytime the NTSB comes out with some new information. But it's scary right now flying. I don't think I'd get in a plane anytime soon until things start getting straightened out. But let's take a look.
A new report out today, just released by the NTSB hours ago, shows Boeing, the maker of the aircraft, was aware of an issue with the part that led to the UPS plane crash, and they knew about it for more than a decade.
Well, the NTSB has just issued an update from that dreadful crash out of Louisville, Kentucky, of UPS Flight 2976 last November. The question, the takeaway from this report is, what did Boeing know? When did they know it? And more specifically, what did they do about it? All right, I'm going to unwrap all of that for you as we move forward today. But let's do a short recap of what happened. If you're not familiar, or it's been a while since you've looked at it, UPS 2976, taking off out of Muhammad Ali International Airport out of Louisville, Kentucky, is en route to Honolulu, Hawaii. There are 3 crew members on board the MD-11 aircraft, formerly a McDonnell Douglas aircraft, now owned by Boeing when they bought them out. That's where Boeing comes into all of this. Shortly after takeoff, and I mean, they hardly even got airborne. They had already lost their number 1 engine. That number 1 engine had come off the wing completely, flown over the top of the number 2 engine, fighting it out and causing it to lose power. And at that point, the flight was kind of doomed. They got up to 184 knots altogether, but they couldn't get enough thrust to get airborne, and they crashed. Let's take a look at that just to refresh our memories, and just a trigger warning, this is hard to watch. Right here at that point in the takeoff roll, you can see the big fireball on the left wing. The engine has already departed. It's already come off and flown up over the top of the wing, and it's gone over the top of the number 2 engine, coming apart. All those metal fragments, like shrapnel, coming apart, get sucked into the number 2 engine, causing it to compressor stall and lose power itself. And then they crashed into the buildings off the end of the runway. And everybody on board was lost. 11 people on the ground were killed, and scores of others were injured. It was covered extensively in the news. We covered it here on this channel. But since then, now the NTSB came out with their preliminary investigation. They've come out with something that's kind of unprecedented. This is an update. It's not a bulletin. It's not a preliminary report.
Not for nothing, I've always wondered how these engines don't come off, or the wings don't come off on these planes. And it's always been, if anything that I've ever been freaked out about is an engine or a wing coming off. And this, this is a nightmare.
It's just an update on what's going on. And I think there's kind of an effort to be more transparent over there at the NTSB these days, which is refreshing. That's really nice to know. And it's got a bunch of diagrams and so forth in it that are very helpful for us to understand exactly what took place with this MD-11. But the big issue, the big question here is Boeing. And what did Boeing know? When did they know it? And what did they say about it? And I'll get to all of that in a minute. So November 4th of 2025 at about 5:14 in the afternoon is when they took that fateful takeoff roll and never got really airborne, and the airplane crashed. They did a preliminary investigation shortly after that, and they zoomed in almost immediately on the aft bearing, the aft attachment point, if you will, to the number one engine. Now, both of the wing-mounted engines have a forward and an aft attachment point, and it's a complicated assembly. There's a great big bolt that goes through it. There's a thing that's called a ball element that the bolt goes through. On the outside of the ball element is a thing called a race, and the race goes all the way around the ball element and kind of, couples it and holds it there in place. There's a little bit of wiggle room in all of this on purpose. It's designed to be that way. If you made it completely rigid, every time you hit a bump or turbulence in that airplane, it would just jar and it would cause damage to both the engine and the wing. So you got to have a little bit of wiggle room in there. So there is, and that's by design. But when you have that type of wiggle room, you also get a little bit of room for friction, and friction can lead to cracking. So they've got to examine those things on a regular basis, inspections. Boeing had set up, I think, an every 5-year inspection cycle on this, which is a point I'll get to in a minute. I think that was far too long. I think it should have been shorter than that. But hindsight's always 20/20. Let's take a look here at the first diagram. And this first diagram is kind of the big picture. If you see the little airplane over here to the left, it shows you the left engine, and it's got kind of highlighted there the pylon that holds the engine onto the wing. Then there's a blow up of that pylon, all right, down at the bottom of the screen. What I want to focus in on is this thing in the blue box. All right, it's a pylon mount bulkhead or aft bulkhead, and that round circle right there in the middle, right by where that little red dot is, that's where the bolt goes through. Right, and they don't have this in the diagram, but the bolt goes through there, and you can't really see the wing clevis. It holds it on underneath the wing clevis and so forth, and underneath the pylon. So you might say, why didn't they inspect this every flight? Isn't that something that the pilots would look at, or maybe the maintenance workers would look at? Well, the problem is all of that is covered up by panels. It's inside of that pylon, and so it's just, you'd have to unscrew everything and get into it, and there wasn't a need to inspect it every flight. Was there a need to wait 5 years? I don't think so. I think it should have been inspected more often than that.
Can you imagine how many things that have to be inspected on a plane? And, obviously DEI is definitely part of the problem. Let me know what you guys think in the chat. That now what's happening is you have just so much stuff happening to airplanes recently, with not only pilot error, but here it looks like it's going to be a maintenance issue. And, the recent private jet crashes as well. In North Carolina, the Greg Biffle crash, but it just seems now that all of a sudden, we're seeing kind of the after effect of all of that stuff that's happening. But just think about all the different things on a plane that could be a problem. And this is like, I've never heard of, a clevis thing before. I mean, what is that? Like, a tire rod, or, it's like, what are all these things? And not only DEI, but then an aging aircraft. It's scary. It's just like going and traveling anywhere now in the air is like, it scares the hell out of me. Let me know what you think.
But again, hindsight's 20/20, right? So that's where the bolt went through, and this assembly around the outside of this spherical bearing assembly, that's what's in question. That race that goes around that ball element is what cracked, and it got fatigued, it cracked, and it came apart in two pieces. Now, let's take a look at the next picture. This is the actual ball element, this thing in the middle.
What's crazy too is how the NTSB can figure all of this stuff out from these little tiny pieces from a plane that essentially crashed and burned and completely wrecked. That's what's crazy.
That I'm discussing with you. You can see a little bit of old grease here at the top and at the bottom, but there's a groove right in the middle. And that groove in the middle is important to us because over here, this thing called the bearing race, if you will, has, see this little piece right here that's broken off? This thing on the left side and this thing on the right side at one point had been attached. It's one piece and it goes around, and this little issue right here that's broken off, that's the tongue that fit into this groove. And it all encompassed or housed that ball element inside of it. This assembly on the left and this assembly on the right were at one point one connected piece. The fracture started right down the middle of it, spherically, all the way around, and eventually it broke. And due to the stress of the engine now coming off the wing, it broke enough that the overstress, it separated in two, and then the whole assembly comes apart. When that happens, the bolt is no longer holding the aft attachment point on the wing. The engine, which is producing tremendous amount of thrust, then pivots up on its own because it's trying to fly. It's trying to fly. It pivots up on its own. It overstresses the forward attachment point, and then the whole thing goes kind of flying through the air up over the back of the airplane.
That's nice. That's nice to hear.
Plane FODs out the number 2 engine.
Wow.
All right, now that thing it's very graphic to look at it. I'm going to show you a little bit closer look at now that bearing race and what happened to it. Over on the right hand side, they've got it color coded for us. So the orange area is all the fatigue that happened over the years. And you're going to ask the question, why didn't they see this? I'll explain that in a minute. The next diagram is going to show you why they didn't see it. All that fatigue is cracked all the way, almost all the way around. You can see the cracking is all the way to the outside here and all the way to the outside on this side, and it's on the inside in here. And the yellow is the overstress that happened when it finally let loose and that engine came off. So both this side and this side were attached to each other. You got to get that part. They were one piece of metal, one hunk of metal at one point that went all the way around that ball element. Once that thing let loose, it was they were doomed. That engine wasn't going to stay on the airplane anymore. Now I'm going to read something to you here in just a second. But I want to get to this diagram because this is the important diagram. This one, it's all colored for you. And you can see over here the bolt that goes through this, and you see the dots here, right? The dashed lines. That's that ball element with the bearing race that goes around it. Here is another look at it, schematic view of it. There's the ball element. You can see how it looks here. Right? Remember the grease here and the grease here? This thing, this white line right here, is that groove that goes down the middle. And the blue part is that bearing race that goes all the way around it, okay? But they didn't put it all the way around because they wanted you to see what's underneath on the diagram. Now, the inspectors were told every 60 months to go take a flashlight, look in here with a scope, and see if there was any sort of migration, that's the word they use for it, or a protrusion of this bearing race right here. This thing is supposed to be out of sight. So if you can look through right here, and you can look through right here and you don't see anything, you're good to go. That thing is in place and it's intact. But if you can't see all the way through, or this thing is sticking out a little bit over here, or it's sticking out a little bit over there, there's only one reason for that. And that means somewhere inside here, preferably right here, or presumably right there, it's cracked. And now you know you got a fatigue crack in there someplace. Now you got to go take the whole thing apart. And Boeing suggested replacing it with a whole new part that didn't have that tongue and groove assembly in it.
Yeah, so I was just about to say, so it seem, of course, I don't know how to build these things, but it seems overly complicated with all these different parts that you couldn't make that a more simple, like, contained unit or bolt or something. You have all these different little parts that have to be inspected every 5 years. And then you have to put a scope in there, and then you have to decide whether or not it's fatigued, whether it might be a microscopic crack in it, or protruding, or any of this kind of stuff. It seems like these things are so antiquated now that we can't modernize any of this stuff. And here they're saying, yeah, it should have been completely replaced, and it wasn't. Now, how many of these planes are out there right now? Passenger planes. This was a UPS plane. But how many passenger planes are out there right now that have this issue? And I'm sure, everybody's looking at it now, but it took several people to die before they do.
Now, let me read to you what Boeing said specifically here about this particular issue that they found. All right. Boeing service letter dated on February 7th, 2011, informed operators of 4 previous.
Jay, bro, it's not political yet. I'm kind of warming up to that. I just thought that this was kind of an interesting thing. So everybody that's here, stay tuned, because we are going to get sort of political. I can't help it. I have to.
Reported bearing race failures on 3 different airplanes. That implies that one airplane had it on both engines. Okay, on both sides. So there were 3 different airplanes where they looked and they saw this little assembly right here protruding, and they knew that it was a problem. So they opened it up, and sure enough, the spherical bearing assemblies had gone bad. Specifically, each failure had initiated at the design recess groove on the interior surface of the bearing race. That little groove that I showed you on the previous picture over here, that little groove right there.
Yeah, it's funny. I'm starting to realize now that people that do come in here can turn anything, any story political, which I think is great. But yeah, it was political, actually, when I was talking before about DEI and all kinds of different things, and pilots and stuff like that. So, and there was, and I think who just mentioned it, Larry, that that there were stories, I don't know if they're true or not, and you guys probably know better than I do, that there were a lot of pilots that, because they were forced to take the shot, that had heart attacks, and there were like a significant amount of pilots that died as a result. And again, I'm just saying that these are reports. I can't verify them. This is alleged, because I don't want to get in trouble with YouTube, but you guys, I know out there, probably know it better than I do, but there was some controversy about that too.
And this little tongue that went in it, that's where the fatiguing took place. This is, in my opinion, a design flaw. You don't need the tongue and groove here. It's just something they designed it with. But with that tongue inside that groove, it creates a friction motion that can lead to the fatigue and the cracking. If that wasn't there, they wouldn't have that little pulling moment every time there was an adjustment in the engine. And over time, it just created a crack.
Morning, Captain. Thanks for coming back.
If they had gotten rid of that altogether, which they did in the new redesign, which they came short of saying here later on, that you had to replace every bearing on every airplane. They said, if you see it and you want to, go ahead and replace it. They left it up to the owners, UPS, FedEx, and the others, to make that decision on their own. And that's the delicate ballet that goes on between an aircraft manufacturer and the aircraft owner. It's kind of like your car and my car, right? You get maybe a 3-year, 36,000-mile warranty, or 100,000 on,
You guys see, but the two in New Jersey, the helicopters, that this is a crazy story where 2 guys each owned their own helicopter and would fly to a coffee shop, or near like a coffee shop, for, I don't know, like 20 years or something like that. And those guys would go there and have coffee once a week or a month. I can't remember how long. And on that particular day, they both took off and collided with each other. And I think they both perished in the accident. But that was just kind of one of those freak things. But these guys were doing that for so many years, and something like that tragic happened. It's crazy.
the major parts of your car. And after that, you're kind of on your own. And the manufacturer will come out with some ideas and some suggestions, but it would be on you to go out and get it done. And so there's some tension here between the culpability of UPS and the culpability of Boeing on all this. And remember, Boeing didn't design this airplane. This was a McDonnell Douglas airplane. So Boeing inherited it, but guess what? Once you buy the company and you buy the airplane, you buy the liability.
There you go.
And the responsibility for it. So having said that, they did come out in 2011 with a bulletin that said, take a look at this. They knew about it. They pointed it out, but they came short of saying replace it all. And in hindsight, I think that it would have been most wise for them to have replaced all of these, especially given the 1979 crash of the DC-10 that had something very similar to this go wrong with it. I think it would have been very prudent on their part.
And to me, that's unacceptable. So this happened in 1970. This obviously happened before, decades before. Granted, but at the same time, there's no excuse for this kind of shit. And this is an interesting story to me because a lot of people fly. A lot of you do. And El, what's up? Thank you for subscribing. But this should never happen. This type of stuff should never happen. And it's bad enough now that we have, you look at Spirit Airlines and people are kind of joking that Spirit Airlines looks like a Waffle House now. It's just so uncomfortable and terrible to fly these days on commercial planes, and now obviously on private planes as well. But then to have to worry about whether or not you're not going to make it to your destination because of shit like this. It's unacceptable. Just simply unacceptable. And people should not have to put up with the terrible service that these airlines provide. And then on top of that, and I've always said for the longest time, and I'm not blaming this necessarily on DEI, but there is a lot of DEI issues that, I've said for a long time. You start introducing DEI into air traffic control, maintenance, things like that, then people are going to die as a result of it. And that just is completely unacceptable.
To go all the way with this thing.
Yeah, they're flying
sure
Waffle Houses.
that they fixed it and they fixed it right. But again, sadly, many times it's tragic in this industry. The loss of life is the thing that leads to getting something done. I have said before, I don't think you're going to see the MD-11 come back. I think UPS and the few others that are flying the MD-11 are looking for an excuse probably to park that airplane permanently and replace it with newer airplanes. I think if I was on a board of directors, I'd probably be making that type of decision. But to recap what happened here, back in November 4th of 2025 at about 5:14 in the afternoon, UPS flight 2976 never got airborne. 25 feet off the ground was all the farther they got when the number one engine came off due to a failure of the bearing race that goes around the ball element that holds the main bolt and that holds the whole aft assembly of the attachment points of the number one engine. Once that came loose, it overstressed itself. It overstressed the forward attachment point. The whole thing flew up over the top of the airplane, fought out the number two engine. You can fly these airplanes on two engines. They'll get airborne at any gross weight, but you can't get airborne on just one engine. Simply not enough thrust. I think the pilots on this flight were heroic. They tried everything they could. Our thoughts and our prayers absolutely go out to them, the families on the ground, the innocent folks on the ground, the many that were injured from this. And folks, I want to say before we get done with this video, I do a lot of reporting on a lot of different incidents, and it's an absolute pleasure to talk about things that went wrong, but nobody got hurt. I think that's very informative and very educational. It breaks my heart as much as is possible to ever cover a story where there's a loss of life. Those are real people with real families with real lives. And let's not lose sight of that here. My buddy Gary down in Florida kind of reminded me about that recently. He was friends with Christina Biffle. And if you followed any of the coverage of the Biffle crash, there were real people in that airplane that had real families and friends. And Gary was a friend of theirs. And so he did a very poignant video. Check out his video on his channel at Gary B. Pilot and watch that.
So yeah, so the Biffle crash was really a shame too. But and Larry, you may know this. I think what they were saying was it would, and I've been in that aircraft before several times, the Cessna, where it's rated for 2 pilots. You have to have 2 pilots unless you get some sort of a waiver, I guess. And Biffle was a pilot, was licensed pilot, I think, to fly that plane, but the pilot's son was on there, and so I think they were trying to find out whether or not it was the son that was in the co-pilot seat or if it was Greg Biffle. I don't know what's happened regarding the investigation and where that stands, but I'm curious to know like what caused that, because those particular type of light private planes are used a lot, and like I've said, I've been on them. I probably won't go on them again because the same thing happened with Dale Earnhardt Jr. And it was a similar plane. It wasn't the same plane, and I think in that case it was pilot error. I think they came in too hot in the runway. But again, it depends on who you're using as, the pilots, if you hire them or if they're, through the company or whatever it is. But yeah, I'd be curious to know what happened there. Okay. So I want to move on to what's going on in the Supreme Court right now. And another great YouTuber, this guy's a lawyer. He's a self-defense lawyer, but there is, and I told you we're going to get political, but this has to do with Title IX and transgenderism, whether or not trannies are able to play in women's sports, and the argument for those for it. It's kind of crazy. We'll just go ahead and get into the video and listen to it, but it's pretty crazy, the arguments that are being made. And keep in mind, before I start any of this, really what it comes down to, the fact that this is even in the Supreme Court, Title IX, Title IX in and of itself is destructive. But when you come in, especially for men and men's sports, and this is where all of the crazy leftist communists try to, destroy the nuclear family, make sure that people aren't, having kids, and destroy the patriarchy because they don't want the white race to continue to flourish. So anything they can to try and destroy that, and that's why this stuff ends up ultimately in the Supreme Court. But sports, this transgenderism in sports was never an issue until recently, until communism started kind of gaining a foothold into things. So let's take a look at this video and we'll comment.
People cross-dress who aren't transgender. This is not a classification on that basis.
What do you do with the legislative history in this case, where the people who introduced the bill called it a transgender bar? So you in answering Justice Gorsuch, you said there's no evidence of that, but there's certainly a lot of comments in this bill when it was passed.
Your Honor, I respectfully disagree. I am aware of nothing in the legislative record that says that. I know that the Ninth Circuit opinion says that, but if you'll notice, the key quote that the Ninth Circuit relies on puts the words transgender women in brackets. And if you look up that colloquy in the legislative record, in their transcript that they provided in the district court, the word transgender, gender identity, et cetera, do not appear in that section of the transcript.
Can I go back to the mootness question?
Oh my God, he just blew up Sotomayor. Sotomayor's whole question is, well, you're saying that they weren't being targeted for being transgender, but the people who put the bill forward in the legislative history, they said it was a transgender bill. No, they didn't. They literally did not do.
Yeah, Ketanji Brown Jackson says, I think later in this says, when she was being interviewed by Congress or confirmed by Congress, she said she couldn't answer what is a woman, and she gets into that in this case.
That Your Honor. Those words were added in brackets. They were inserted by other people later. They were not actually said. So much for that question, that line of argument, Sotomayor. So now, of course, she has to change the subject.
Of record in their transcript that they provided in the district court, the word transgender, gender identity, et cetera, do not appear in that section of the
Can I
transcript.
go back to the mootness question that
Let me-
Justice
let me go
Thomas
back.
talked about, but not
got me.
addressed here at all? Yes, this respondent made certain allegations about her intent at a certain point.
Her
But she
intent.
signed an affidavit with this court attesting that
She's Sotomayor is talking about the dude who's suing to play in women's sports, the guy with XY chromosomes. Sotomayor is referring to this person with XY chromosomes using the female pronouns. Oh, dear Lord. I guess she's not a biologist either.
she has permanently stopped playing sports covered by the ban. She will not try for any school-sponsored women's sports, and in fact, I think she'll finish school very shortly. And there's no reason to question the sincerity of that belief, given that dropping out of sports puts you at a disadvantage where you lose your competitive edge, and she's going to graduate soon. How is this different than Atchison Hotel, where the person in the litigation made representations that she intended to visit and continue visiting hotels in the future? And then, when the case got before us, she voluntarily dismissed those suits, like here, with prejudice. And we then
So what they're addressing here by mootness, of course, is sometimes somebody brings a lawsuit, they want a remedy, they're claiming some damages and want a remedy, and but then things change, circumstances change, and the remedy would no longer be relevant for them. Someone wants to sue to, I don't know, run in the Boston Marathon. They're not being allowed for some reason. And then while the suit is progressing, they get in a car accident, they become a paraplegic, or they become killed. They're killed. So the lawsuit would be dropped because you can't provide that person with the remedy they desire to run in the marathon, right? They're dead. So generally, unless there's a possible remedy that could still be pursued, there's no reason to move forward with the lawsuit. Or if someone just chooses to dismiss the lawsuit, then it becomes moot. They're just not seeking a remedy. There's no reason to go forward with the litigation. And that's generally what's done. The litigation would just be dismissed. You run into problems with that, however, when it's going to be, you can reasonably expect this to be a recurring point of litigation. It's going to come up in the courts again and again. And you don't want to be in a position where the courts can never settle the issue because it keeps becoming moot.
So what he's saying is that there's two cases, by the way, in the Supreme Court. And this particular one, what they're saying is, or Sotomayor is saying, well, you know, this she is not going to graduate, or is going to graduate. So, you know, they don't really care anymore whether this goes to court. And everybody's saying no, because we have another case that's coming up. Plus, is obviously now a problem. It wasn't decades ago. Now all of a sudden, it's part of it. It's a problem, an ongoing problem now because of communism. They're not saying communism, but because it is, and the destruction of the nuclear family and the destruction of a particular race. So yeah, it's going to be an issue, and it needs to be addressed, and the Supreme Court needs to address it now. Because the secondary case that they're going to be talking about, and cases going on beyond that, there's going to be more on these people. And it's basically people who can't make it in there. And there is one argument, I'm not sure if it's in here or not, but it's like, and I was a tennis player. So if you have somebody playing tennis, and let's say I'm a tennis player and I'm unable to make it on the men's team, well, I'll just change my gender and start playing on the women's team. I mean, that's basically what this is. You know, people will argue it and say, oh no, that's just the way that I feel. But this wasn't, you didn't see this 20 years ago. You didn't see this 30 years ago, 40 years ago. This is all just recent. This is all a new recent thing because you have people now that actually are in government, in these bureaucracies like the NCAA and other sports, regulatory kind of things that are making these decisions, and it has to be addressed in the Supreme Court. He can't let it go
before a decision can happen, and therefore it keeps getting litigated by different people over the same issue again and again and again without ever having a resolution. This used to be a problem in, and I know this is a politically charged topic, but in a lot of the abortion litigation before Roe v. Wade, a woman would sue to be allowed to have an abortion, and this lawsuit would take long enough that by the time it got to the courts, she already had the child. Well, you can't abort a live child, and no matter how much the left would like to be able to do that. So the cases would be dismissed as moot, and it always takes more than a few months to litigate these things. So it effectively made it impossible to litigate over abortion laws. And ultimately, the Supreme Court just said, listen, this is just going to keep happening until we settle this legal issue in the wrong way, of course, later reversed by the Supreme Court. So that's what will be argued here. What Sotomayor is trying to say is, hey, this plaintiff, she's offered to dismiss the suit with prejudice. She'll never come back. She's going to be leaving school. She's promising she won't try to get into now I'm doing it. This man is promising not to play in women's sports. He'll be graduating soon. There's no remedy to grant this male who previously wanted to play in women's sports. And I expect what the lawyer here is going to argue is, yeah, but we can't allow that to stop the litigation because this is going to happen over and over again with different litigants until we get this settled.
That the case be considered moot. How is that different?
To begin with,
I add one further difference between the two cases.
Certainly.
Here, it's not like she's attempting to avoid us reaching the question. In just a little while,
The lawyers are, though.
the identical question in another case. So we don't have a subterfuge in attempting to stop the court from reaching an important legal question.
So what Sotomayor is referring to here is they have a second case. They're actually hearing oral arguments on two separate men in women's sports cases. This is just the first of them, Little v. Hecox. The second one they're going to hear right after this, yesterday they heard it too, is West Virginia versus a second case. So a lot of times what will happen is someone will bring a lawsuit, and when they think it's going to go against them, they'll dismiss the case so they don't develop bad precedential law for their team, for their side. So there's a subterfuge motive for being willing to dismiss the case. Here Sotomayor is saying, well, we don't really have that element here because right after we argue this case, we're arguing a second men in women's sports case.
I'll start with Atchison Hotels, Your Honor. In Atchison Hotels, no one disputed that plaintiff's plans going forward. In this case, even the district court does not credit the plaintiff's plans going forward. The district court struck the notice of dismissal and said Hecox's plans have changed before. Hecox's plans could change again. And also, the court feels...
let me address it. Just some going back and forth in the chat. The midterms, I would have agreed even like a month ago, maybe more, that the Republicans would be in trouble because Trump wasn't doing what his base voted him in to do. But I can tell you right now that Trump is turning that around significantly. And he can, without question, if he continues to do what he's doing, can definitely win back the base. And I can also tell you right now, with what is going on in Minnesota and other states too, because there's a lot more of this criminal activity that's going on that they're finding out more about, that the leftists support and love. They love criminality, they love violence, they love all that stuff. The cracking down by federal law enforcement on that stuff is really getting and I'm not necessarily MAGA. I don't consider myself that. I just like right and wrong. And I'm for doing the right thing, not the wrong thing. And to me, there's really not a lot of gray area. But with Trump and all this stuff, cracking down on the criminality, cracking down on the fraudsters, cracking down on these violent protesters, which is what they are, he's definitely getting back the support. I think that he may have been, it might have been slipping away earlier on.
Feels that this is somewhat manipulative in order to escape the Supreme Court's jurisdiction. None of that existed in Atchison Hotels, and that puts us in City of Erie territory, where in that case, the premises were sold, the business was closed, the owner was in his 70s, and they said, that's not enough. You could still reopen this business. Your company is still incorporated. Under these circumstances, where it's the respondent seeking through post certiorari maneuvers to moot the case, that isn't enough. This case isn't moot.
Thank you, Counsel. Justice Thomas.
Does the justification for a classification as you have in Title IX, male-female sports, let's take, for example, an individual male who is not a good athlete, say a lousy tennis player.
Here we go.
And does not make the women's and wants to try out for the women's tennis team. And he said,
I think he meant tries to play on the men's team and then doesn't make it on the men's team and goes to try and play on the women's team.
there is no way I'm better than the women's tennis players. How is that different from what you're being required to do here?
It's not all different, Your Honor, and that's exactly what we're concerned about, that their arguments about needing to make exceptions from an otherwise valid classification for people for whom that classification doesn't make sense, those arguments don't limit themselves to people who identify as transgender. Many males could say, I can't really compete with the women's basketball team, and therefore I should be able to try out. And I haven't seen an answer from the other side as to why they couldn't, beyond, I correct myself. They say that, well, those people don't face the same dignitary harm as transgender people. But I don't see how that's relevant to the intermediate scrutiny analysis. The analysis is this classification substantially related to a legitimate state interest? The person's reasons for wanting to violate the classification don't come into the analysis.
Justice Alito.
Justice Sotomayor raised the question whether the issues here are identical to the issues in the case.
So, by the way, Clarence Thomas, his question is probably the most, and all of this stuff is so ridiculous that it even has to be argued. This should never even be an argument. Like I said before, these are issues that 20 years ago were never even a thing. All of a sudden, transgenderism is an issue. All of a sudden. And once again, it's what it is. You see the people that are in this chat. Unfortunately, this is about, just destroying America. It's about just ripping apart the traditions of America, what America was built upon. And, just moreover, really the traditions of everything. And then, to destroy it and bring in communism to tear down the country, destroy it, and then rebuild it back into a communist, what they think is a utopia. But we all know how communism over the decades has worked out. It hasn't. But Clarence Thomas brings up the most simplistic argument. Well, what's to stop anybody from saying that if I can't make the men's tennis team, I'm going to go play, if I'm a man, I can't make it on the men's tennis team, so I'm going to go ahead and play on the women's team or try out for the women's team. Who's to stop anybody from doing that? And there's nothing in Title IX that specifically goes outside of man and woman. Now, the argument they're trying to make is, on the other side, is that somehow it can be interpreted that way. And they're going to lose this case in the Supreme Court. It's just not going to happen. They cannot make transgenderism all of a sudden part of Title IX when it never was part of Title IX. And there's plenty of oral arguments within the Supreme Court that had said, very clearly, even on the other side that's trying to make the argument for it. Well, it doesn't say that. It's just an interpretation. And if you have a biased court, the biased court might say, oh yeah, well, we interpreted it that way. And you can't do that because it's not in Title IX.
We're going to hear in a couple of minutes, and I'd appreciate your views
communists they're violent thugs.
Affirm or reverse in this case.
Definitely not deep thinking.
In the other case. Would that leave something undecided with respect to your case?
Yes, Your Honor. Our case involves the issue of the constitutional definition of sex, which the Ninth Circuit made a decision about, what sex means for constitutional purposes. The Fourth Circuit did not make that decision. We will be bound by that decision going forward unless the court reaches that question. That said, I would dispute the premise of the question, because whether or not the court has Article III jurisdiction in this case does not depend on what the court might do another day in a different case.
No, that wasn't the premise of the question. It was just an attempt to explore.
Thank you, Stanley. Thanks for subscribing.
Deciding the mootness issue one way or the other. Thank you.
Thank you, Your Honor.
Justice Sotomayor.
There's a Munsingware GVR that's being agreed to here. so you're not bound by anything in this case. And our decision there will inform any new decision in the Ninth Circuit on this issue, correct? Whatever analysis we adopt in the Little case will control what happens in a new case.
That is the law, Your Honor, yes.
With respect to the Erie case, there, the 90-year-old man never said he didn't intend to open another business. He just said this business. And that was the distinction we saw. Here, she has said, I don't intend to do this. Now, every other promise that she made in this litigation, that she was going to continue trying out, that she was going to stay in sports, held true until this case and the negative attention she received, correct? To say she misrepresented her intent is going a little extreme when she honored all her previous intents and only changed her mind when new circumstances arose, i.e. the notoriety of this case, correct?
No, Your Honor, nothing changed externally to the plaintiff.
Again!
The plaintiff's affidavit filed in this court says that there has been negative attention and so forth since the beginning of this case. The only thing that changed is this court granted certiorari, and then after that, the plaintiff said, I want out, and so I will stop playing sports.
Do you dispute that having a case named after you makes your infamy live forever?
No,
You don't think that Brown and any of the other named plaintiffs that we have in famous cases drawn attention to those people as people? Have you studied your law cases? Students do all the time. I think one of my colleagues had a court.
What? What? She's talking about cases, of course, like Brown versus Board of Education, Arizona versus Miranda, Roe v. Wade, although, of course, Roe was a pseudonym. She's asking a lawyer who's a member of the Supreme Court bar. That's what privileges him to stand before the Supreme Court and argue. She's asking him.
And by the way, this guy, when you're listening to this guy make his arguments, the guy is incredibly smart. I mean, his recall is insane. And that's probably why he's arguing in front of the Supreme Court. And he's making the left argument justices look like idiots. Because it's so easy. When you are telling the truth, it is so much easier to tell the truth and use common sense and have an argument with someone when you're just using the common sense and truth on your side. But if you have to twist things and say, well, they identify as, or, when somebody asks them, okay, well, what is a woman? And they can't answer it. And they look like idiots. And here's somebody who's a justice on the Supreme Court who can't answer that. Since when can you not answer that question? Well, just recently, because communism has gained a foothold in America. But when you have the truth on your side, it's just an easy thing to make an argument. But this particular lawyer who's arguing against Sotomayor is just like, his recall is insane. I mean, the cases that she's trying to use to argue against him, he's going right back and saying, no, you have no idea what you're talking about, in a very nice way, of course. But these arguments, they're just not going anywhere. And I think the side that is trying to push for this is coming to the realization that they're not going to win. And so for them, if they're able to pull these cases out of the Supreme Court and the Supreme Court doesn't make a decision, that's a win for them. But I don't think that's going to happen. I think it's going to push forward. Plus, there's another case. So,
have you not studied law cases?
Course, where they looked at the lives of the plaintiffs. Do you doubt that having a named case with such an eventful event is going to continue attention on this person?
I don't doubt there will be attention, and I confess
negative attention.
I confess I have studied a few law cases, but
have you studied the people?
To some degree, Your Honor. What I would disagree with is there's no background principle of plaintiffs get to leave the litigation whenever.
You see how she starts to insult him in sort of like a, underhanded way. He's just kicking her ass verbally with facts, and she's trying to, criticize him Have you looked at, of course this guy, he probably knows way more cases than you do. And he's arguing in front of you.
They want. Even Rule 41, even in just the district court, the rule is that once the litigation hits a certain point, you can't leave.
What you're going to assume, I know you don't want to, that you were to lose this case, you would say that we have to force an unwilling plaintiff who has offered to dismiss with prejudice, promised not to incur this activity again, we would force that person to continue prosecuting this case.
Why wouldn't you? You brought it up. You're the one who wanted to bring this up and take it all the way to the Supreme Court. And then all of a sudden, now that you know you're going to end up losing, you want to pull it out. You just pull out. You don't want to do it anymore? No, you don't get to do that. Not when it comes to this kind of stuff. And you see the games that they're playing. Oh, we know we're going to, it's like playing a tennis match. And I've done this as a tennis player. It's easy for me to talk about. If you're playing in a tennis match, this has happened so many times that when I've played through high school, college, everything else, pro, that if somebody else is losing and they don't want to take the L, they retire, which means they'll fake an injury or say that they're sick or something, and then they'll quit. Instead of playing all the way through and finishing the match and taking the loss, they would rather give up. And that's what you're dealing with. You're dealing with children. You're dealing with people who, like somebody said earlier, that you're just dealing with people that aren't deep thinkers. And so instead of playing by the rules and playing fair, what they decide to do is, I don't want to do this anymore because I know I'm going to lose. And that's what's happening. I think Captain said it.
The court did in City of Erie.
That it did there, but is it the right thing to do? We didn't do it in Atchison.
Doesn't matter. It's two
In
totally
Atchison,
different cases.
No one disputed that the case was moot. The only question was which Article 3 question would be decided first. In this case, we dispute the case is moot. We dispute all the facts that this is based on. It is a formidable burden that Hecox bears. That's from Nike, already be Nike, to show that it is absolutely clear that this conduct cannot be reasonably expected to reoccur. We think as the...
God, Sotomayor is coming across as so
ignorant,
almost Katanji-esque in weakness of her legal argument, which already is just based on emotion.
The district court said in its striking order that based on the changing history here, based on the past conduct, as Scalia mentioned in his footnote 3 of his City of Erie concurrence, there is a reasonable basis to doubt whether Hecox's current plans are the final plans. And as long as there's a reasonable basis not to credit the current plans, Article 3 lets the court hear the case.
That's a simple enough argument for me.
Justice Kagan?
Mr. Hurst, I want to take you back to our conversation about whether there's such a thing as applied equal protection challenges, and ask you for two things.
Keep in mind, this is Ketanji Brown Jackson, who during confirmation hearings was asked, what is a woman? And there's a meme basically about it, like a meme video with her, with this dumb look on her face, not able to answer it. So this is what we're dealing with.
The first is I do think that runs counter to a couple of things that we think of as basic principles of constitutional law and maybe equal protection law particularly. In constitutional law, we often say as-applied challenges are the preferred mode of constitutional adjudication. Certainly, we have not erected bars to them in any other area as far as I understand it. And then in equal protection law, we say all the time things like people need to be treated as individuals and not just as members of a group. And I'm wondering whether both of those principles don't suggest that any bar on equal protection, as applied equal protection challenges, is just wrong.
Yeah, let me pause real quick. We got a couple hundred people in, over 12,000 views in total today. Do me a huge favor. Those of you that are here, even if you don't like me, subscribe, because it's good to have argument back and forth. I do like having people in here that, if you're constructive and you're not violent with your words and everything else. I mean, you can be strong with your words and things like that. I don't care, but it is good to have people in here to kind of argue back and forth certain points. So please do me a huge favor and subscribe. It would be greatly appreciated. So when I do go live, you will be notified.
Long is off. And then the second thing I want you to do after you do that is assume for me that there is such a thing. Okay. And to tell me how, in your view, an as-applied equal protection challenge ought to work in this case.
Certainly, Your Honor. The first answer would be, I recognize those principles that Your Honor is alluding to. The contrary principle would be the very nature of intermediate scrutiny analysis, that it is always possible, if you only have a substantial fit supporting legislation, then it is always possible to find people whom it doesn't fit, and then we're in strict scrutiny.
So I completely take that point, Mr. Hurst. I mean, you're exactly right, and of course, intermediate scrutiny is different from strict scrutiny. It doesn't require the, almost perfection that strict scrutiny does. Completely take the point, but isn't that point really addressed to what we often consider in these areas, which is to facial challenges, right? So when you bring a facial challenge, of course, that's right, that you're allowed to have over-inclusiveness and under-inclusiveness and a lack of a perfect fit, but that the nature of an as-applied challenge is different.
Certainly the court could do that, Your Honor. The court has not done that before, as I think we both agree. And the result of that would be judge-made exceptions to laws anytime judges thought they didn't make sense for particular classes of plaintiffs. And the deference to the legislature that should exist, to some degree, even under intermediate scrutiny, would be done away with. It would be gone. And then the administrability justification for many sex-based classifications, including this one, would also be gone, because you could no longer administer the classification evenly. You would have to make as many exceptions as courts thought you needed to make. So it's really an institutional competence.
That's another thing. Think about, when you have LGBTQ, and then they keep adding letters and things like that to it. Think about, how long and how difficult it would be every single time somebody says, oh, well, I identify as this, or I'm this, or I'm that. Think about, the amount of, decision-making, paperwork, all the stuff that has to be done in order to, make these decisions on who's able to play here and who's able to play there, all that kind of stuff. An important point of one of these things was just simply Title IX with men and women's sports without any transgender stuff is Rutgers University. Rutgers University in 2012 eliminated their men's tennis program. And the reason they had to do that is because of Title IX. And because those Title IX restrictions made certain universities open up their schools to more women's sports, Rutgers University, and there were other universities as well, eliminated completely their men's tennis program. Now, regardless of what you think about tennis as a sport compared to football, basketball, or anything else, they're not going to eliminate football, they're not going to eliminate basketball. But for tennis, which is a very popular sport in all colleges, they decided to eliminate it there, which to me is an absolutely horrible thing to do. And so that in and of itself was a bad thing when it came to Title IX. And now just think of all the administrative issues that people have to deal with now with what this justice is bringing up, is that just think about all of the administrative issues because of every little women want that somebody wants to have when it comes to playing sports in school.
Or institutional power thing between courts and legislature.
So you're suggesting to me that the whole thing is just unworkable and we shouldn't, but flip to the second prong of my question, which is, suppose we said, where as applied equal protection challenges exist as applied anything challenges do. What would it look like, do you think? What should it look like?
Yeah, I'm not sure what it should look like. I can say what it does look like in this case and why we think there's a problem with it.
So you're not willing to take me on my second path, which is like, let's assume that there is such a thing as this challenge.
Yes. I mean, the
how
most
should
I
we
can
do
say, I doubt this is a satisfactory answer, Your Honor, but the most I can say is that the as-applied nature of a challenge might go to the remedy. The legal analysis still focuses on the classification and the justification for the classification. And once we're talking about individuals, we're not talking about a classification anymore.
Yeah, I mean, that doesn't seem like much of an as-applied challenge, right? You have to prove the exact same things you do in a facial challenge, but don't worry because you only get relief as to you. So that's not a true as-applied challenge.
And I'm having trouble coming up with what it could look like, because it will always be possible to carve the class down further, right? I mean, so if they say that their class, that their subclass, I guess, subclass of males is males who identify as transgender, then we would come back and say, well, only something like 10.
And see, you could, and again, making fun of sports and people playing sports and stuff like that, regardless of it, always remember the man in the arena. I can't remember what president came up with it, but when people go out there and they put themselves out there, they get in front of people and talk, or they play a sport, those are the real heroes, because they actually get out there and they're the man in the arena. You have people that are in the crowd that shout at them and make fun of them and stuff like that. Those are the losers. And the losers will make fun of everything that they can't participate in, because they're jealous of the fact of there's the man in the arena and they can't do it. And so these are the things too, hopefully as I do more of these live streams, that I can help people understand. I'm sure a lot of you already do, but probably a lot of you don't, is that, you're always going to have people that are out there that criticize, but you have to keep in mind the people that do the criticizing are the losers in life that never have accomplished anything, never tried anything, never became good at anything. And so the best thing for them to do is criticize those who play sports, who get out there and have an opinion, get out there and talk to, thousands of people, get out there and run for office, all those types of things. So those of you who are out there that are good people, just keep that in mind. The people that you're watching right now that are criticizing and doing these things in the chat, think about who they are, and think about, how miserable their lives are, and that they've really never accomplished anything. So the way to make themselves feel better is to say the things that they are.
10% of males who identify as transgender take the testosterone suppression. And then they might say, well, okay, no, the class is just the males who take the testosterone suppression. And then we might come back and say, well, according to the record, according to their own expert, of males who take testosterone suppression, only 1/4 of them are able to achieve the appropriate, able to achieve ordinary levels of testosterone for women. And the other 3/4 would still have an advantage, and therefore we'd be justified 75% pretty good fit and intermediate scrutiny, and we'd be justified with the law. But then they can just change the class again. They can say, aha, no, our class is males who identify as transgender, who suppress their testosterone, and who suppress their testosterone successfully and are able to get it down to where they don't have a competitive advantage.
There's the administrative issue. So what this guy is saying is, so how many classifications are we going to have? Is it just going to be a dude that can't make it on the men's tennis team that wants to now play on the women's tennis team? Or is it a dude that's taken suppression drugs, and have they been successful or have they not been successful? Because the argument from the other side is, well, they're taking drugs, so they're suppressing their testosterone, so that doesn't make them as strong. Well, that's obviously arguable and obviously not true. So it may suppress some, it may not suppress at all, but it's still a male. And so there's still that danger or that possibility that, especially in a contact sport, boxing or even basketball and things like that, that somebody can get hurt because of that guy playing in the women's sport.
And at that point, we can say, if you can define the class so precisely, you're going to force the state to define the class that precisely. It's going to be enormously burdensome for everyone, and the state can never win, because whenever the state points to the fit in the statute, they just redefine their class as only the people who are outside the fit.
Thank you.
Great argument.
Justice Gorsuch? Justice Kavanaugh?
To follow up on something you were talking about, Justice Sotomayor, would your constitutional position be different if the law explicitly stated that transgender women and girls cannot participate in women's and girls' sports?
What's a transgender woman or girl? Doesn't he just mean man? Doesn't he just mean a man? who's pretending to be a woman or a girl?
My answer to that depends on what's in the rest of the law. So I would refer back to Skermetti and say it's not a magic words test. The mere presence of the word transgender in the statute.
Gloom, I agree. They should have the NBA guys play against the WNBA. And again, I keep bringing up tennis because I know tennis, but they've had men versus women. They had a guy who was 100 in the world, I believe it was. It might have been even less ranked than that. It might have been 200, but I think it was 100. Played against Serena Williams, who many believe that she used steroids throughout her entire career. So she was like dominating the women's tour. This guy was like a smoker, and I think drank a Coke or beer or something, and beat her like easily in straight sets, like 6-0, 6-3, something like that. So that I would have fun, or I think it would be fun to watch those types of things, men versus women in those sports. I think that would be cool.
It's not enough to make it a transgender-based classification.
Was it 134?
If the law either expressly or through it.
What was the guy's name? And I think he would. Some people are saying 210 in the world, 134. Was it 0-1? Yeah. So it was an absolute beatdown. And even Serena Williams admitted, it's like, look, I can't compare it to these guys. Now, if you take that and you extrapolate it to a male playing in a woman's sport, okay, so he's taking suppression drugs. Does that really make a difference? I don't think it does. Yeah, he smoked her like bad. And a guy like that was never even heard of on the pro tour because he was ranked, over 100. So just imagine, Roger Federer or Rafael Nadal or Novak Djokovic, guys like that, she may not have even gotten a point. That's the difference between the two. And to say that some guys can go and play in women's sports, and just because they're taking drugs to suppress their testosterone, that doesn't make a difference. I mean, it just doesn't. And my argument would be, well, why not just have a separate, you have a men's sports and women's sports, why not have a transgender division and let them play on their own? They can get their own referees, they can get their own organization, they could set up all of their own stuff. Just do that. And what I find interesting is that they don't want to do that. That's the easiest remedy to all this. Just create your own organization. Call it whatever you want to call it, the transgender division. And then you guys can all play, basketball, tennis, whatever, all in your own thing and organize it on your own and all that kind of shit.
Its effect, let all males except males who identify as transgender participate in female sports, but made it so that somebody's ability.
Thanks, Jimmy. Yeah, Carson Bosch, German tennis player, 203 at the time. Yeah, thank you.
To play in female sports depended on transgender identity.
Assume that the law does not allow males to play in women's and girls' sports, and then explicitly says, in separate provision, transgender women and girls, biological males who identify as female, cannot play in women's and girls' sports. Would your constitutional position be any different in that situation?
No, Your Honor, I think that's Skermetti. I think that would be a reference to transgender identity, but the law's application would never turn on transgender identity, so it wouldn't be a transgender status.
Even if it says transgender?
The word transgender in the statute might be relevant to a pretext analysis, but it wouldn't be relevant to the facial classification if that word did not change how that statute applied in practice.
How many states allow biological males who identify as females, transgender women and girls, to play in women's and girls' sports?
Statutorily, I'm aware of 27 states that take our side and do not permit that, and 23 states that take the other side and do permit it.
And those states who do allow it, is your position that they are violating the Constitution, the equal protection?
Okay, new poll. I'm shocked at that. It's almost 50-50. New poll. So, do you think it's safe to fly now? Some people are asking questions because they came in late. That why did I ask that question? Do you think it's safe to fly now? And the reason is because of the UPS flight where the engine came flying off of the wing. The NTSB came out and said that there was I already forgot what it was, but some components that were holding the engine to the wing were faulty and needed to be replaced, and they're recommended every 5 years to be replaced. And I guess it didn't happen, and so they became fatigued and broke, and that's why the engine came off. And we were discussing whether or not many different things that are going on, including DEI and age of the planes, and the complication of all these planes and everything else. Is it safe to fly currently? So it's pretty close, but barely. The poll is 54 to 46. So the majority, as small as it is, believe that it is not currently safe to fly. And I would agree with that. So I'm going to create one more here before we wrap it up for the next several minutes here. And again, those of you that are still here, please be sure to subscribe so you're notified when I go live again. It looks like during the week, I won't be here on Monday. I'll be here again tomorrow morning. But during the week, we're going to be doing 2 p.m. on a regular basis, except for Monday, because I will be away on Monday. But be sure you subscribe so you know when I do go live. And then also tomorrow, I'm thinking probably 10 or 11 tomorrow morning as well.
Clause rights of biological girls and women by allowing that, or do you say that's up to each state to decide, and that the Constitution gives discretion to the state whether to allow it or not to allow it?
I have not yet.
So this is a great point. There's by Kavanaugh. So there's multiple levels of possible remedy here, right? The Supreme Court could say, as a matter of constitutional law, you have to let trans men in women's sports. That would be one option. They could do the opposite. They could say, as a matter of constitutional law, women have a constitutional right and interest to be protected from trans men in their sports. So it's not allowed as a matter of constitutional law. Or you could say it's up to the states to decide. Each state gets to decide whether or not they want men in women's sports, and if they decide either way, that's constitutionally sound. Which wouldn't surprise me if that's where they came down. That's how they reversed.
Joshua, the reason why is she knows, but she is placating the left. She's placating those who were supporting her, that ultimately wanted her on the Supreme Court in order to make those decisions that would benefit communism, essentially, and destroying the nuclear family and the patriarchy and white race, et cetera, et cetera. That's why. I mean, shoot. So, a lot of this stuff, I even have to keep reminding myself that this is all by design. These people know. I mean, she knows the answer to that. But these arguments, and that's what's so frustrating about the Supreme Court, is having to, just like the Supreme Court's having to decide whether or not it's legal to have a gun without having to have a permit. So New York and New Jersey is going to ignore the Supreme Court and still make you have a permit to own a gun and have a license to conceal carry or carry at all. I mean, we have a Second Amendment. So, for states to be able to make laws like that, they shouldn't. And the same thing here. It should be decided federally.
Roe v. Wade, right? They didn't make abortion illegal. They just said it's not a constitutional right, therefore we're going to leave it up to each of the 50 states to decide for themselves.
I'm persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter.
Okay.
Justice Barrett.
I have some.
So just to be clear, what this lawyer said was it's our position that we would accept state by state. We're not asking that nationwide no trans men and women's sports. We don't recognize a legal doctrine that would allow us to make that argument. I'm sure that's what they would prefer, but he's only arguing for my state with this statute. It should be found to be constitutional.
Questions?
Yep, I'm persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter.
Okay. Justice Barrett?
I have some questions about the implications of your theory. So how would your theory play out if we're talking about 6-year-olds, where there's no difference between boys and girls in terms of athletic ability, testosterone levels, et cetera? Could you have sex-separated teams then? Or sorry, sex-separated teams by biological sex and not allow trans girls?
Certainly, Your Honor. First, I'd like to explain how the statute.
It's so funny. Sometimes some of these justices refer to them as trans men, and she just referred to them as trans girls. It's so insane that there's not even standardized terminology for it.
Because it's so new. It's not there's no standardized terminology because it's completely nonsensical. When you're making up stupid shit, and again, this hasn't been around for decades. This has not been a thing, and now all of a sudden it's a modern thing. And so so when you're coming up with wacky shit, you can't come up with terminology because it's that wacky, and it's completely, again, nonsensical.
To that situation, so I can put my answer in context. There are no 6-year-olds in the state to whom the statute applies because there are no school-sponsored.
That's why it was a hypothetical.
Okay, right. Yes, it would be the normal intermediate scrutiny analysis.
Why bring it up then?
And are we saying it applies only to 6-year-olds or to everybody across the board?
Well, I'm just trying to give you a yours is driven by testosterone levels and differences in athletic capability. So I'm asking you, what if you try to take that out of the equation? And you're just drawing the line based on biological sex and saying that trans girls can't be on the girls' team in an age group that's prepubescent.
The record in this case does not support the notion that males lack an athletic advantage at 6 years old. That's about as early as the science goes from what's in the record. And even at that age, males have about a 5% athletic advantage over girls in most situations. Now
that's not even, should even be talked about, because here's the thing. If you have a boy competing against a girl at that age, and the girl happens to beat a boy because they might be somewhat similar and because they're that young in athletic ability at that point, what do you think that does to the male mentally? And once again, this is also another hypothetical that somebody like, I forget who said it, but it's just another hypothetical to basically say, no, why is there such an assault on men? Even from the right-wing judges that were appointed by Trump, why is there just this assault? We have to just assault men, and white men are like the worst thing that's ever happened to anybody. I mean, it's just this constant assault, and this is another example of that. Is that, these kids, even from a young age, should be separated from a mental standpoint to give these kids, not make them lose their confidence because they happen to lose to a girl because they're similar in athletic ability at that particular age at that moment.
If this is not a level of competition where anybody cares about that, the simple solution is the solution you see in most places, which is you have co-ed sports. You don't divide the teams based on sex, and everybody can play. And Idaho's law does nothing to interfere with that.
And remind me whether Idaho's law, and I guess your answer made me think of this, and I guess this goes to the question of whether the law discriminates on the basis of trans status. Is it true that biological girls, trans boys, can play on boys' teams?
Anyone can play on boys' teams, Your Honor.
Anyone can play on boys' teams. Okay. And to this point about medical uncertainty and scientific uncertainty, you were talking about what advantages you might have even that are apart from testosterone levels. Mm-hmm. Your friends on the other side say that, listen, that science is uncertain, and so we need more factual development. It's not really clear how much of an athletic advantage boys and men have if their testosterone levels are below a certain point. How does that play out? Tell me why we don't need more fact-finding, or what is the state's burden in showing what the state of scientific certainty is? Do we have to defer to the state? Presumably at some point, if deference is due, the state would have too little scientific evidence to really get that deference. Tell me how to think about that.
The first question would be, are we applying intermediate scrutiny? And we argue that the court shouldn't. But leaving that aside, if the court is applying intermediate scrutiny, Then we'd say it's Turner Broadcasting that says the legislature, First Amendment case, applied intermediate scrutiny and said under intermediate scrutiny, the legislature has to draw reasonable inferences from substantial evidence. It does not need to act only on scientific consensus, which is what the district court in this case assumed incorrectly.
Thank you.
Justice Jackson?
Okay, Justice Jackson is coming up. So I'll do my little reenactment. So, you can go to the Supreme Court and you can try to get in.
We'll listen to this for the last 10 minutes and we'll cut it off. So, again, make sure you subscribe. It looks like this is a first. 100% men should not compete in women's sports. Pretty easy question.
To listen to oral argument, normally you have to get a reservation online. For lawyers, if you're a member of the Supreme Court bar,
and you're right, Gloom. Both parties have fallen. I think that we should all agree on that. That both parties are not interested in helping their constituents. They're worried about helping themselves.
like I am right there. If you remember the Supreme Court bar, you can pretty much always get in. There's a separate process and separate entrance and separate
Yeah, and Captain, people should have a license to breed.
Listen to an oral argument. It's public.
They should have a license to
so
have
you see
animals.
them all up there on the bench,
pets,
like they're arrayed here in this image. And so Clarence Thomas is right next to Roberts, right? He's one of the more senior justices, so he's right there in the middle. Then it declines by how long they've been a justice out to the edges. And normally Clarence Thomas is sitting there and he's wearing glasses. And he wears the glasses the whole time and he's quiet. He doesn't say much. And then every time Ketanji Jackson starts talking, and Clarence Thomas does this, he takes his glasses off and he unlatches his chair and he puts his hand on his head like this and he just leans back like he's having the biggest migraine of his life. And he just stays there the whole time she's talking. And then when she's done talking, he sits back up again, latches his chair, puts his glasses back on, and he's back in the game. It's so funny to see. I wish they televised it so everyone could see it.
They need to televise this or record this stuff. Absolutely need to record it. The people need to be able to get into these courtrooms and see what's going on. The fact that the public can't see, like, for example, see Clarence Thomas, with those emotions and the arguments and things like that. It's a huge injustice to the American people to not watch that. And and I don't know, I was talking over the thing, but Captain, people should have licenses to have kids. That'll never happen, of course, but they certainly need to have licenses to own animals and dogs and things like that. There needs to be more of that. I think they do that in I think it's in Sweden. You actually have to have a license to own a dog.
He's in so much pain when Ketanji Jackson starts talking. It's hysterical. All right, back to Jackson.
So I guess I'm going back to your discussion with Justice Kagan. I'm not sure I understand why you're characterizing the as.
Oh my God, I had a mouthful of tea. That was it. She made it 35 minutes in. All right, let's hear it again.
I guess I'm going back to your discussion with Justice Kagan. I'm not sure I understand why you're characterizing the as-applied challenge in practice as the individual coming back and proposing a different classification, as though we're doing an analysis of the classification in the way that you suggest. I thought that the state has a classification that is its general rule. No individuals who identify as female but were sex at birth male can play in women's sports, and that the individual then is merely seeking an exception based on their individual capacity, because the state's general rule is based on fairness and medical science and all of these things. Do I have this, like, they're not proposing an alternative class necessarily. They are just saying that I should be accepted from that general rule on this basis.
We agree that an exception is what they are seeking, Your Honor. And And it's an exception based on transgender status. Again,
But that's the way the rule used to work, right? I just want to be clear about what we're talking about here.
sure.
I understood that this law originally was exactly that, that you basically said no transgender women in girl sports, but we'll look at your evidence and look at your circumstances and decide whether or not you individually can be included.
So
is that what used to happen?
As a matter of Idaho law, there was no law whatsoever before this.
Is that what was happening on the ground in Idaho law?
That's what NCAA policy permitted from 2010 to 2022. Before 2010, the NCAA policy matched ours. Since 2025, the NCAA policy has matched ours.
Okay.
But
what I'm asking is if that's the ask here, not that all transgender women be allowed, but that this particular plaintiff be allowed based on their circumstances, why is that so not administrable or proposing a different classification that we're not going to be able to sustain?
Because then you'd have to do it for everybody. If everybody says, well, I can't make it on the men's team, then I'm going to go and play on the women's team and be successful. I mean, this just, you see how these arguments, and we'll see how this guy answers it, but it's like, no, it needs to be black and white. Men play on men's teams, women play on women's teams. That's it.
Understand.
So first to administrability, Your Honor.
Man.
Making sure that a transgender athlete does not have an unfair advantage would require ongoing testosterone monitoring because circulating testosterone can fluctuate. That is invasive.
Who pays for that?
The person who wants to play has to demonstrate to you, to whatever degree of scientific certainty, that they don't have a competitive advantage. Why would you not allow that? I guess I don't understand.
And first of all, you can't do, just because you measure somebody's testosterone level has no bearing on whether or not someone can hit 130 mile an hour serve or not. You know, there are a lot of strong women that are tennis players and other athletes and stuff like that. So just imagine you have a man, and just because they're taking testosterone blockers or whatever it is, they could still be strong. How do you monitor that? That's impossible to monitor. You don't have to be a doctor or an athlete or anything. It is impossible to monitor what their strength level might be on whether or not they can compete.
The second answer is...
Oh my God.
It's ridiculous.
That's three I don't understand in 2 minutes. 3 I don't understand in 2 minutes. That might be a new record.
Yeah, Captain, that's a great point. I want to play in the NBA. I wanted to play professional tennis against Roger Federer. So do I get to skip the line and say, well, you know, I identify as a way better tennis player than I actually am. So I want to be able to play in Wimbledon against Roger Federer because why do I get to do that? I mean, people will look at me and laugh. But here's somebody who's like, well, you know, I identify as this particular person, and so I want to be able to compete in women's sports even though I'm biologically a male. How is that the same thing?
The second answer is that there's nothing in that argument
this guy's frustrated.
that limits itself to transgender identifying athletes. If this athlete doesn't have an advantage over women and therefore can compete safely, then there are other athletes that could say for different reasons that they don't have an unfair advantage and therefore they can compete safely.
Yes, I understand that, and there are legal arguments. Let me ask you something about
she just lost that argument.
The classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis.
Wait a second. I was reading something.
Understand how you can.
Oh yeah, that's another one.
I understand that. And there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how.
She can't go a minute. She can't go a minute.
This is great.
Without saying I don't understand. Oh my Lord.
You can say, and I understand that, and there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis of transgender status. The law expressly aims to ensure that transgender women can't play on women's sports teams. So why is that not a classification on the basis of transgender status?
I'd apply Skermeti again. The question is whether the application of the law turns on transgender status, and it doesn't. It turns on sex. The legislature did not want to exclude transgender people from sports. It wanted to keep women's sports women only and exclude males from women's sports.
No, I understand. But with respect to two individuals, a cis woman and a trans woman, who both want to play on a team.
What does that even?
Yeah, and that's a good point Bethany brings up too. Why are all of the Hollywood actors and actresses, why do they have so many trans kids? Somebody explain that to me. Explain to me why it is that that's being pushed in Hollywood. There's a reason for it.
What is a cis woman? What does that mean? Is that just a woman? Is that what that means? I guess I'm not hip on all the terminology. I think cis woman just means woman. Couldn't you just say the word woman? But she doesn't know because she's not a biologist.
That reflects their gender identity. This law operates differently based on their sex, right?
The law does operate differently based on their sex, as Your Honor just said. It does not operate differently based on their transgender identity.
But it treats transgender women different than cis women, doesn't it?
It has a disparate impact because men who identify as transgender have a different reason for wanting to play women's sports than women, than biological females do, right? But if that were enough, then Skermeti would have come out a different way, Gaduldig would have come out a different way, other cases would have come out a different way. I'm blanking on the other ones.
All right, finally, let me just ask you about mootness, because it's a little odd, I think, that a defendant would not want a case dismissed. Ordinarily, the defendant is the one who's claiming mootness because they've been sued. So this
is an idiotic question. This is literally idiotic. Why would a defendant not want the case dismissed? This is like 80 IQ thinking. You've been sued, the case gets dismissed. Aren't you happy? Not if there's going to be an organized campaign of transgender after transgender after transgender suing us over and over and over again. And then when they realize they're going to lose, simply dropping the case so it becomes moot and we never have a legal resolution. It'd be like a team in a Super Bowl getting to the fourth quarter. They don't want to take a loss. They're down by 40 points. They just walk off the field.
Yep.
We didn't lose.
That's exactly right.
It's a justice on the U.S. Supreme Court asking this question. It's just horrifying.
plaintiff has been on a case. I think that a defendant would not want a case dismissed. Ordinarily, the defendant is the one who's claiming mootness because they've been sued. So this plaintiff has brought a claim against you, and the claim relates to your policy.
But and what he brought up is exactly what I brought up before, is if you're playing a tennis match and you know, I'm winning and my opponent says, oh, I pulled a muscle and quits because they don't want to take the loss. That's what this is. And that's what they do. You put up with this little baby games, these little kids games that they play. It's like, oh, well, why wouldn't, why is it not okay for them to just say, well, this doesn't apply to me anymore, so I'm just going to quit? No. You brought it up. It needs to be argued, and it needs to be made law that, women should not have to be abused. Now, let me just say this one. This is kind of karma. Title IX, I've always said Title IX karma. Title IX is karma, or this is karma for Title IX. Now, Title IX is to really not benefit men's sports at all, especially in college. And now you're having this issue and you're saying, well, wait a minute, I don't want these transgender men or these men that are competing in, Title IX karma. But at the same time, the argument doesn't make their argument wrong.
About college sports. And as I understand, the plaintiff is about to graduate. So wouldn't we have a mootness problem?
No.
Potentially notwithstanding any representations that the plaintiff made?
I don't think so, Your Honor. I'd look to Camreta as the case that tells us the best case for telling us how we analyze moot.
By the way, he already addressed this. He was already asked this by Sotomayor, by Kagan.
This was already talked
about. The third
about.
of the Supreme Court crones, the SCOTUS crones, I call them the scrones. She's asking it again. He's already covered these cases.
is in this situation. It's, does the petitioner still have an interest in continuing the litigation?
Only for a few more months. What if this decision doesn't come out until June and she graduates in May?
It's my understanding at this point, I defer to my friends here, it's my understanding at this point that May graduation is not possible.
For this individual?
For this individual, that's correct.
All right, thank you.
Thank you.
Thank you, counsel.
So there you go. 31 votes. Should men compete in women's sports? 100% say no. I think that's pretty clear. So there you go. All right. I think we'll call it a day. A few minutes over. Everyone that's here, thank you. And once again, may I remind you, if you haven't subscribed and you are here and you're chatting with us, please explain to me why you haven't subscribed. You're making me sad that you haven't subscribed yet and you're still here. Those of you that have subscribed, thank you very much. I appreciate it. Make sure you also click the like button as well. I know on these lives, it's a little kind of wacky on how to do it. Let's see. I think it's the 3 buttons in the top right hand. Yeah. The 3 buttons on the top right hand corner, if you click those, click the like button. And also, like I said, subscribe to the channel because we have other videos as well, long form videos and other short videos that are that I post regularly. I've been spending a lot more time doing lives, which has been a lot of fun, especially with all of you that are in here, those who are against the what's right and those that are for what's right. It's good having different views and things like that are in here. So Gloom, thank you. Beast, thank you. Joshua, Jason, Bethany, of course. Captain, of course. And everybody else that, if I miss you, I apologize. We had a lot of people. Jimmy. Tex. So thanks for sticking around. We appreciate it. And we will see you tomorrow. I think I might do 10 tomorrow in the morning. All right. Thanks again. I appreciate it and see you all soon.